So good morning, everyone, and thank you for signing up. We plan to give you an overview of the transfer of assets abroad rules and highlight some key points and unexpected results, as well as discuss the recent Upper Tribunal and FTT cases. But a couple of caveats before I get going. Firstly, these rules are immensely complicated and we plan to cover a lot today, but we'll still barely be scratching the surface. And secondly, there is a wide range of expertise in the people who registered. So please forgive us if we pitch this incorrectly for you personally. There is, of course, a chapter on these rules in my book, Tax Avoidance, which covers the points for today in a lot more detail and contains further explanation of all of the provisions, many of which we won't even get onto today. So there have been 4 recent cases, 2 in the Upper Tribunal and 2 in the FTT. These cases themselves only touch on certain narrow aspects of the rules, and we will cover these along the way, but what I hope to do first is put these cases in their legislative context. So the rules themselves are found in the Income Tax Act 2007, Part 13, Chapter 2. I'll call them the TAR rules for short, but that is not to be confused with a targeted anti-avoidance rule, which is something else entirely. And despite the rewrite, they are still very difficult to construe. The basic purpose of the rules is fairly easy to grasp. So the TAR rules were first enacted in Section 18 of the Finance Act 1936 to combat avoidance which took advantage of a fundamental rule of UK taxation, which is that a non-resident person is not chargeable to income tax in the UK on foreign source income. So prior to Finance Act 1936, it was relatively easy to avoid income tax by moving the income offshore. And we see that in the early cases. So for example, the case of Litilla, which was heard in the House of Lords in 1941, where the taxpayer was a UK resident individual, had transferred an interest in a partnership to an offshore company, a Rhodesian company, in 1932 in return for debentures. The partnership income was received offshore by the company, and until Finance Act 1936 was enacted, the offshore income was not subject to UK income tax in anyone's hands. And then the profits could be returned to the UK by the taxpayer as tax-free capital at a later date. So in effect, the income was enjoyed tax-free in the UK by a UK resident person. And you can see why Parliament would legislate to stop that mischief. But the legislation is very widely drafted, and it's also become far more complex. And also the TAR rules were applied very broadly by the courts from the outset because they frowned on tax avoidance as they do now. And you can see this from the comments of Viscount Simon LC in the House of Lords in Litilla and in other cases such as Congreve, which I'll come on to. So these factors have contributed to the uncertainty surrounding their application. And they also produce some very counterintuitive results, including, in my view, the answers to the questions on the slide here. So what if the transfer takes place entirely abroad? Do the rules still bite? Can a person who has not avoided income tax be caught by these rules? What causal or other connection is required in order for the person to be chargeable on foreign income? Now, the question of causation and connection comes up in different contexts under the 3 different heads of charge, which I'll tell you about in a moment. How much of the foreign income can a transferor with no power to enjoy it be charged to income tax on? And the question of quantum also arises separately under each head of charge, but this one to me is the most surprising. Does a person have to be a transferor of assets for the TAR rules to bite? And there are different answers to this question depending on whether you are looking at the legislation alone or applying the case law. And finally, what defences and reliefs are there? So we'll touch briefly on the motive defence conditions and EU infringement, but we won't be covering the case of Davis today. I don't think we'll have time anyway, but there will be a whole 11's session on sort of treaty issues, including the case of Davis. I believe that is next week. So I mentioned there are 3 heads of charge. So the first 2 heads only apply to a person who is a transferor, and we'll come on to what that means shortly, as well as why. So the first head applies to a transferor who has power to enjoy the income of the person abroad. And in terms of quantum, under this head, all of the income arising to the person abroad is potentially deemed to arise and be chargeable on the transferor, regardless of whether he in fact receives anything at all. And there are several detailed conditions which determine whether a person has power to enjoy, and they are notably broad. The second head applies to a transferor who does not meet the power to enjoy conditions, but who receives or is entitled to receive a capital sum, which is in any way connected with the relevant transaction. And I'll explain in a moment what relevant transaction means, because that's a key phrase. So income is treated as arising under section 728 under this head, and there are 2 key points to note. First, that the timing does not matter in terms of the relationship. So the transaction may be before or after the capital sum is received. And second, that this is the most surprising head, as I've said, in terms of quantum, in my view, because it deems all of the income of the person abroad to arise to the person who receives or is entitled to receive a capital sum, even if the capital sum is only nominal in comparison. The third head of charge applies to any person who receives a benefit out of assets which are available for that purpose as a result of relevant transactions. And here the income is treated as arising under section 732. So in terms of quantum, the amount chargeable under this head will usually be lower than the total amount of income arising to the person abroad. And that's because there are some calculations to be done under section 733, which relate to the benefits received rather than simply the total income arising to the person abroad. This head used to only apply to non-transferors, but from 1718 onwards, it applies to transferors in certain circumstances, but not where either of the first 2 heads of charge apply or the beneficiary has already been charged to income tax. So those are some key pointers in terms of how the 3 heads of charge operate. And as you will have gathered already, there are certain conditions which have to be met in order for any one of those 3 charges to apply. So I will deal with those now. So we are told at the start of the chapter in section 7142 that the charges only apply if a relevant transfer occurs. Apologies, that was my post arriving. A relevant transfer occurs and that the charges operate by reference to the income of a person abroad that is connected with the transfer or with another relevant transaction. So I'll start with the meaning of relevant transfer, because without that, the provisions are not in point. So section 716 tells us that a transfer is a relevant transfer for TAR purposes if it's a transfer of assets and, as a result of the transfer, or one or more associated operations, or the transfer and one or more associated operations, income becomes payable to a person abroad. So in order for there to be a relevant transfer, there must be a transfer of assets. I'll come on to the meaning of that. there must be income arising to a person abroad, and I'll come on to the meaning of that, and the income must arise as a result of the transfer or associated operations, or both the transfer and associated operations. And I'll come on to the meaning of associated operations too. So it may be that income would not have arisen abroad but for a particular transfer, but that does not necessarily mean that income arises as a result of the transfer. So it may arise as a result of something else. And then the question we would have to ask would be whether that something else is an associated operation. So for example, if you were to transfer a share in a partnership, as was the case in Latilla, and then the activities of the partners cause the partnership income to arise to the person abroad, that would be an associated operation. And so there would be income payable to the person abroad as a result of the combination of the transfer of assets and an associated operation. Therefore, there would be a relevant transfer in that situation. And indeed, there was found to be a relevant transfer in that case for that very reason. You'll see that more clearly when I come on to explain what an associated operation is. So the legislation uses the phrase relevant transaction to encompass a relevant transfer or an associated operation. But as I've noted, the starting point is the transfer of assets to the person abroad, because we can't have an associated operation without that. So first of all, it's essential to know what a transfer of assets is and who a person abroad is. So there are two key elements to a transfer of assets, namely the asset and the transfer. So section 717 defines assets for this purpose to include property or rights of any kind. And section 712 provides that transfer in relation to rights includes the creation of rights. So entering into a contract under which a person abroad acquires rights is a transfer of assets for this purpose. And that was what happened in the case of Hoey. So there was no dispute between the parties in that case that there was a transfer of assets. A couple of key points to note. A transfer of assets does not have to be a gift. It may be a sale for full consideration. For example, a sale of shares to a newco in return for shares of the same value or loan notes. And there's no requirement for the assets to be situated in the UK. So the transfer can relate to overseas assets. So next, what is a person abroad? Oh, sorry, getting ahead of myself. So this is defined in section 718 as a person who is resident outside the UK or an individual who is domiciled outside the UK. There's a deeming provision which extends certain deeming provisions which treat trustees and personal representatives as non-UK resident. So that extends that deeming to this chapter. And there's also a deeming extension with the opposite effect, so that a person who is deemed domiciled under section 835 capital B capital A of the Income Tax Act is not a person abroad. So they're deemed to be domiciled in the UK for this purpose as well. What is an associated operation? So the term associated operation is very widely drafted, and it exists in relation to the transfer of assets. So it's defined as an operation of any kind affected by any person in relation to any of the assets transferred, any assets directly or indirectly representing any of the assets transferred. So I'll refer to those as A and B. And C, the income arising from any assets within paragraph A or B, or any assets directly or indirectly representing the accumulations of income arising from any assets within A or B. And it doesn't matter whether the operation is effected before, after, or at the same time as the transfer. So for the purpose of B to D, this includes shares or obligations of any company to which the assets, income, or accumulations have been transferred, or obligations of any other person to whom the assets, income, or accumulations have been transferred. So applying that to a very simple example, suppose that I own a trading company and I transfer the shares in the trading company to a non-UK resident holding company. So let's say I have power to enjoy the income of the holding company. The trading company then pays a dividend to its new parent company. So the transfer of assets in this example is the shares, and it's as a result of the transfer of those shares that the offshore company receives a dividend. So there's likely to be a relevant transfer in that situation. But the trading activities of the company are not operations in relation to the shares in that company or in relation to other assets or income which represents the shares. So those trading activities should not be an associated operation. And it might be arguable on the facts for some reason that it isn't the transfer of shares which caused the dividend, but instead the activities of the trading company as a result of which the dividend is paid. And if that were right, then there would not be a relevant transfer. So the difference in Latilla was that the operations were affected in relation to the assets transferred to the offshore company. And similarly, you'll see in the case of Fisher, which Sam is going to discuss, that because it was the business which was transferred to an overseas company and the income from that business or trade was reinvested, there were associated operations which gave rise to the trading income in the offshore company. It didn't matter in the event because the Fishers were found not to be caught by the rules anyway, for reasons that we'll come on to. There are some older cases in which it was found that certain transactions were not associated operations. So for example, the case of Finn and the IRC and Carville and the IRC. But in summary, the question whether there are associated operations is a very fact-specific issue. So those are the basic concepts which underpin all three heads of charge, but I just wanted to make some other points which are relevant to all three heads of charge. So firstly, does a person have to have avoided income tax in order for the rules to bite? Now, the TAR rules can apply regardless of whether a person intended to or in fact did avoid income tax. So in McGuckian, the taxpayer intended to avoid income tax, but was caught by another anti-avoidance provision which was overlooked. And the taxpayer argued that the TAR provisions did not apply because income tax had not in fact been avoided, but the House of Lords rejected that argument. And then in the same year, the legislation was amended to include a provision, section 7391A of ICTA, which is now section 7215C of the Income Tax Act, making it clear that there was no requirement for any purpose of avoiding a liability to income tax in order for the rules to apply. Now, the preamble to section 739, which is now in sections 721 and section 7271 for the capital sum head, refers to the purpose of the rules being to prevent the avoidance of income tax. And for each of the first two heads, it says the charge under this section applies for the purpose of preventing the avoiding of liability to income tax by individuals who are UK resident by means of relevant transfers. So some people take the view that the preamble must mean something. Therefore, since there's no requirement for a purpose of avoiding income tax, then income tax must in fact be avoided in order for the provisions to apply. But I don't see how that follows. The preamble simply states the intention of Parliament in enacting rules. And rightly, in my view, it wasn't argued by the taxpayer in Fisher that income tax does not in fact have to be avoided in order for the rules to apply. So you'll see that income tax was not in fact avoided by the Fishers. But in that case, Parliament's intention, or the mischief of the rules, was taken into account in relation to the main argument that the shareholders of the company transferor, SJA, were not themselves transferors and were therefore not caught by the rules under the House of Lords decision in Vesti, which I'm coming on to. So the next fundamental point is the answer to this question, and the answer is yes. The transferor need not be in the UK when the transfer is made, but he must be UK resident for the tax year in which the income is treated as arising for both the first and second heads of charge under 721 and 728. And that is because section 7215B provides that it doesn't matter whether the individual is UK resident for the tax year in which the relevant transfer is made, if that's different from the tax year in which income is treated as arising under section 7211, and that's repeated for the second head of charge under section 7283. So in relation to the third head of charge under section 732, the person charged on the benefits provided need not have anything to do with the transfer, so it doesn't matter where he is at the time of the transfer. And nor does the situs of the assets matter, as I've already mentioned. So there's no requirements for the assets transferred to be situated in the UK. The transfer can relate to overseas assets. So in summary, the rules can bite in relation to a transfer of overseas assets by two non-UK resident persons. And the final burning question relates to the first two heads of charge, because the third one plainly doesn't require a person to be a transferor. So you've heard me describe the legislative conditions, and I didn't miss out a requirement for the person to be a transferor. There simply isn't one. So there must have been a relevant transfer, but on the face of the legislation, that could be done by anyone. So this has led to quite a few cases over the decades. So early on in the case of Congreve, which again considered Section 18 of the Finance Act 1936. So that case involved a series of transactions which were highly complex and artificial, and Mrs. Congreve did not make a transfer. But at this time, there was no third head of charge for beneficiaries who were not transferors. So HMRC sought and succeeded in applying it to non-transferors. Now, the legislation was subsequently amended to include the third head of charge, but the big difference to the position under Congreve is, of course, that a person charged under the first head of charge is charged on all of the income arising to the person abroad, regardless of whether he receives a benefit. So the consequence of the decision in Congreve was that a person with power to enjoy the foreign income could be charged on all of that income, even if he had nothing to do with the transfer and did not receive a benefit. And Lord Simons gave the lead decision in that case, and the rest of the House agreed with him. So he said, in relation to the taxpayer's argument for restricting the charge to transferors, "But I see no reason for any limiting words. The language of the section is plain. If there has been such a transfer, as is mentioned in the introductory words, and if an individual has, by means of such transfer, either alone or in conjunction with associated operations, acquired the rights referred to in the section, then the prescribed consequences follow. In the present case, such a transfer was made, although not by Mrs. Congreve. The section at that time required the acquisition of rights for the power to enjoy, but it no longer does that. So this case was considered at length by the House of Lords in 1979 in the case of Vesti, and by that time the rules were in section 412 of the Income Tax Act 1952. But this was still a time before they had been amended to include the beneficiaries head of charge. So HMRC sought to apply the TAR rules to beneficiaries of trust. And the House of Lords investee refused to follow Congreve, and the purpose of the legislation was critical to their reasoning. So Lord Wilberforce said, "I find the section, if directed at transferors and benefits taken by them, an ample and powerful anti-avoidance instrument." And also that the words "such an individual," which are still in the legislation, should be interpreted as applying only where the person sought to be charged made or maybe was associated with the transfer. Because they hark back to the opening words of the preamble, namely to individuals whose purpose is the avoidance of liability to tax, and do not refer simply to an individual ordinarily resident in the UK. And then he went on to say, "It follows that in my judgment, the extension of section 412 by the judgment of this House in Congreve to beneficiaries wholly disconnected with the original transferor or transferors was erroneous." And Lord Keith of Kinkle repeats the reasoning of Lord Wilberforce and adds, "Finally, the consequences which follow from attributing the wider meaning to the words when that meaning is applied to a numerous class of beneficiaries under a discretionary trust are so dramatically unjust, as the facts of the present case illustrate, that I cannot think it to have been intended by Parliament." And as I've already mentioned, in Fisher, there was no actual or intended income tax avoidance. So when the upper tribunal considered the transferor question, they likened the facts to Vesti for that reason, and found that applying the TAR rules to the Fishers would not address the mischief of the rules. And that appears to me to be part of their reasoning in deciding that they couldn't attribute the transferor company, SJA's transfer, to its shareholders as a matter of fact. So although I said earlier that there is no requirement in the legislation for there to be actual or intended income tax avoidance, it's not irrelevant in considering whether or not the rules apply. It is, after all, if we think back to 1936, the basic mischief of the rules, which is still stated in the legislation. So I'm just going to very quickly tell you what the motive defence is. So this is found in section 737, where all the transactions are post 4th of December 2005 transactions, and for it to apply, either condition A or condition B must be satisfied. So condition A is that it would not be reasonable, draw the conclusion from all the circumstances of the case, that the purpose of avoiding liability to taxation was the purpose or one of the purposes for which the relevant transactions or any of them were affected. So you'll remember that relevant transactions means relevant transfers or associated operations. So if the purpose of any one of them seems in the circumstances to be to avoid tax and not just income tax, then this condition can't be satisfied. And then condition B uses the phrase relevant transactions, but the test is different. So it's satisfied if all of the relevant transactions are genuine commercial transactions and none of them have as their main purpose, so that's a more than incidental purpose, the avoidance of a tax liability. And again, it's any tax, not just income tax. So this appears to me to be a more generous test than condition A, and that's the way that it was applied by the upper tribunal in Fisher. As Sam will explain, the similarities between the two conditions are that both conditions are now objective. So the test is whether it's reasonable to draw the conclusion from all the circumstances of the case as to whether there is a tax avoidance purpose. So for pre-December 2005 transactions, the test is subjective, but of course, purposes and intentions are always tested against the facts. So I'm not sure that there will be any practical difference in most cases in the and in this regard, we're told in subsection 5 whose intentions to take into account. So that's a person who, whether or not for consideration, designs or effects or provides advice in relation to the relevant transactions or any of them. And both conditions apply Willoughby to the question whether there is tax avoidance. So under that approach, we ask whether the taxpayer has suffered the economic consequences which were intended by Parliament in achieving his tax advantage. So I've put the, oh, I do apologise, I haven't been going through the slides. Put the famous quote from Willoughby on the slide here. I won't read it out to you. Most of you are probably familiar with it. So suffice it to say, firstly, that tax avoidance is defined here as reducing one's tax without incurring the economic consequences that Parliament intended to be suffered with that reduction. It's been adopted time and again, this quote, but it's also been noted as not particularly helpful. And secondly, that Lord Nolan also said here that tax avoidance is to be contrasted with tax mitigation, although again, I don't think this takes us much further. So I put the quote from Brebner on the next slide in relation to tax mitigation. So tax mitigation is to organise one's commercial transactions in a way which minimises the tax burden and suffer the economic consequences that Parliament intended. Finally, in addition to the motive defences, there will also be questions of EU infringement. So the questions of freedom of establishment and free movement of capital came up in some of the recent cases. I mentioned that treaty relief and the case of Davies, although the law has changed since Davies, will be considered at next week's 11s. So the next voice you will hear will be Sam on the recent cases. Thank you and well done for staying the course.
Thank you, Rebecca. Just before I start, I've been invited to ask you to put any questions that you have into the Q&A box so that we're better able to address them at the end of the talk if we have time. Before I start, if I can ask Rebecca to hand over the screen sharing to me.
Oh, sorry.
Thank you. I'm going to share my screen. So as Rebecca's indicated, I'm going to go through some of the more recent cases to put those rules into context and to demonstrate how the FTT and the upper tribunal have in particular determined whether persons are transferors and how they've applied the motive defence. The three cases that I'm going to go through today are on screen. That's Hoey and HMRC from July last year, Realis and HMRC from August last year, and more recently Fisher from the upper tribunal earlier this year. Turning first to Hoey and HMRC, there is a brief outline of the facts on the screen in front of you. To go through those in a bit more detail. This was an appeal against decisions to issue closure notices to a taxpayer who'd participated in various iterations of a marketed tax avoidance scheme. Mr. Hoey was an IT contractor, and he was used to providing his services as an independent consultant or through personal service companies or, in some cases, umbrella companies. He found that difficult. Indeed, the FTT found that he found the complexities of running his own company too much for him to deal with. The scheme operated by allowing him to enter a contract of employment with first a trust called Penfolds and later transferring that contract of employment to another trust called Hamilton's. And it was that transfer of his contract of employment from one to the other which was the basis of the charge applied. The outline of the scheme is on the slide, but in broad terms, the structure of the income received under the scheme was that the contractors were paid a basic wage for the work that they did, on which tax was paid under PAYE. The Their employers then made contributions to a trust which provided benefits, including interest-free loans, to the contractors. Those loans were stated to be repayable on demand, but the contractors did not expect to repay the loans. Those arrangements with each employer were notifiable and were notified under the DOTAS regime. As I've said, the FTT accepted Mr. Hoey's motivation in entering into these schemes was solely to avoid the complexities of running his own company or his own business. Although he was aware of the tax advantages of the operations, he did not really understand that this was because he would be paid in a way that was designed to avoid paying UK tax on a large part of his earnings. The appeal to the FTT raised a whole host of issues, not all of which related to the application of the TAR scheme. And indeed, by the date of the FTT hearing, Mr. Hoey had accepted that payments to the trusts which employed him, which were made with a view to an onward loan to him, were properly to be taxed as his earnings. That meant it wasn't strictly necessary in the circumstances for the revenue to show that a charge arose on those payments under the TAR rules, but the FTT very helpfully dealt with the point in any event. Rebecca's already set out the need for a transfer, and in this case, the transfer was Mr. Hoey's transfer of his employment contract. That was not disputed by the parties to be a transfer of assets to which the TAR regime applied. The issue under the TAR regime was whether Mr. Hoey could claim advantage of the motive defence. I've already set out the FTT's finding of fact as to Mr. Hoey's motivation, and in essence, the FTT found that Mr. Hoey's own motivations for entering into the scheme were unimpeachable. They held it was clear from Mr. Hoey's evidence that his motive was purely the avoidance of the complexities of running his own company or his own consultancy. He had no idea that the arrangements involved tax avoidance or anything untoward. So in essence, Mr. Hoey was saved initially by his own ignorance of the nature of the arrangements he'd entered into. However, that did not complete the analysis of the motive defence. The FTT had to consider the transactions as a whole. The question here was whether or not all the transactions were normal commercial transactions, and whether all that was being done was that the taxpayer, or at least his advisors, were taking advantage of the opportunity to reduce tax in a way that Parliament had intended. Applying that to these facts and the scheme in question, the FTT considered that the basic structure of using an umbrella company was a perfectly reasonable commercial transaction. However, it regarded the insertion of additional transactions, being, in this case, the setting up of an umbrella company offshore, which makes payments to a trust, which then makes interest-free loans to the contractors with the expectation that those loans are never repaid, as constituting tax avoidance. The transactions therefore failed condition A of the motive defence that Rebecca's already set out, and so it was necessary for the FTT to consider condition B. Similarly, condition B was failed because some of the transactions, specifically the interposition of a non-resident employer, a trust, and the making of loans from the trust, were more than incidentally designed for the purpose of avoiding liability to taxation. In this case, then, the motive defence fails because of the general way in which the scheme had been set up, rather than because Mr. Hoey had had a specific tax avoidance purpose in entering into the scheme. Moving on to Realas. In this case, this was an appeal against closure notices making assessments to income tax, which were issued on interim dividends paid by a company called Argo Capital Management Limited. And Mr. Realas was assessed on the basis that he had transferred or procured the transfer of shares in Argo. The factual background to that is worth setting out in some detail to see how the situation arose. Mr. Realas was originally the owner of 50% of the issued share capital of Argo Capital Management, and the other 50% was held by his business partner, a man called Mr. Cressman. However, over time, cordial relations between the two partners broke down and Mr. Realas wanted out. He wanted to liquidate his shares. However, when he found a fund management company interested in purchasing the shares, Mr. Cressman put a spanner in the works by upsetting the chief executive officer of that company. So in the event, Mr. Realas was only able to agree terms of the sale which specified that Mr. Cressman would have no future involvement with Argo. Notwithstanding that, Mr. Realas was able to agree a price to purchase Mr. Cressman's shares from him. In those circumstances, Mr. Realas wanted to find a suitable structure to make the purchase which didn't double his exposure to the risk that Argo reduced in value. He did so by incorporating a company in the BVI, which was acquired by a family trust resident in Cyprus. The company was able to borrow on exceptionally favourable terms obtained through Mr. Realas's own personal connections and reputation to purchase Mr. Cressman's shares. When the dividends were paid on those shares, the revenue assessed Mr. Realas to income tax on those dividends. The issues arose as to whether Mr. Realas was the transferor of Mr. Cressman's shares, and if so, whether he could take advantage of the motive defence. On the issue of whether Mr. Realas was the transferor, the FTT found that he was not. He could not be said to have procured the sale of his business partner's shares. Although he had brought that purchase about, he was in an equally powerful position to Mr. Cressman. There was a balance between them. And Mr. Realas did not have sufficient control of Mr. Cressman, such that simply by persuading him to sell his shares, he had procured the sale of those shares. Nor did the fact that Mr. Realas had orchestrated the entire purchase side of the transaction suffice to make him the transferor. As the FTT said, it is stretching the meaning of the word procure beyond breaking point to suggest that the fact that he organised the purchasing structure means that he dictated to whom Mr. Cressman should sell his shares. So Mr. Realas was not the transferor or the quasi-transferor of Mr. Cressman's shares. Again, the question of the motive defence therefore did not strictly arise, but the FTT went on to consider it. So we have their helpful analysis as to how it might apply to that situation. On the motive defence, Mr. Realas's motives for the transfer were broadly commercial, save for the interposition of the non-resident trust. The FTT considered that this part of the structure was considered to have a tax avoidance motive, which, if it had been relevant, would have precluded Mr. Realas from taking advantage of the motive defence. On that point, the FTT followed a 2009 case of Burns and HMRC in holding that where the appellant had not displaced the reasonable presumption that UK tax advantages were one of the purposes, then those purposes involved tax avoidance and not merely tax mitigation. So on these facts, as obtaining UK tax advantages was one of the purposes of using a non-resident trust in the purchase structure, the transaction failed the motive defence. Moving on to the third case of Fisher and HMRC, again, a very brief outline of the facts is on the screen. As Rebecca's already mentioned, the Fishers ran Stan James Abingdon Limited, which was the UK company operating the well-known betting company Stan James. The facts go back quite some time, back to the 1990s. In response to the rise of telebetting in the UK in that period, Stan James Abingdon set up a branch office of their UK company in Gibraltar. At that time, it was possible for a bet to be placed by a customer in the UK overseas without a liability for UK betting duty arising. This obviously meant that UK companies could be undercut very easily by their foreign rivals. This precipitated an inevitable move by UK betting companies overseas, And in fact, there was no major telebetting operator left in the UK by the end of the millennium. Stan James therefore woke up to the reality of the situation that they would have to start accepting bets in Gibraltar. However, they wanted to do so through a separate legal entity rather than a branch of their existing UK business. Stan James Gibraltar was therefore set up and incorporated for that purpose, with some of the Fisher family as directors and shareholders. The transfer took place between Stan James Abingdon and Stan James Gibraltar, when all of the assets that were used for Stan James's telebetting operations in the UK, including book debts, cash, a database of names, a teletext facility, and 4 free phone numbers, were transferred to Stan James Gibraltar. Stan James Gibraltar then began trading, went into profit immediately, and went on to develop other profitable lines of business. The revenue issued assessments to the Fishers on the basis that the profits of Stan James Gibraltar, for each of them in proportion to their respective shareholdings, were caught by the TAR rules. Briefly on the FTT decision, the FTT held that the Fishers were quasi-transferors of the telebetting business by virtue of their status as directors and shareholders of Stan James Abingdon. The FTT also found that the motive defence could not be satisfied because the transfer was designed for the main purpose of avoiding liability to pay betting duty. The upper tribunal, on the other hand, held that the TAR code was simply not engaged. The starting point was that the Fishers were not the transferors of the assets. That was Stan James Abingdon, which owned those assets. So the upper tribunal asked the simple question: can the actions of Stan James Abingdon be imputed to its shareholders or its directors? It noted that there's an equally simple answer to that question. Normally, the answer would be no. It is a fundamental principle of English company law that a company has a separate persona from its shareholders and has separate rights and liabilities. The relevant consideration whether transferor is a company is therefore whether the court can pierce the corporate veil. For example, if the company had been deliberately set up to circumvent a liability to income tax. The upper tribunal then dealt with the revenue's argument that the Fishers, although they're not the transferors themselves, were quasi-transferors. They noted that this concept of a quasi-transferor is a gloss on the statute, which is nowhere to be found in the language used by the legislature. They therefore held that for the concept to apply, there must be some proper basis for ascribing the acts of the person transferring the assets to the individual concerned and treating him as being responsible for the transfer as if he had carried it out himself. On the facts of that case, the upper tribunal considered that it could not apply. The concept of a quasi-transferor could not apply to every transfer made by a company in which the individual concerned has a shareholding or is a director. The logical consequence of that approach would be that wherever a transfer is affected by a company, that transfer will be ascribed to any of its individual directors or shareholders who have power to enjoy income derived from the transferred assets, if that individual was among those responsible for the decision to make the transfer. So what the upper tribunal found was that directors or shareholders cannot be said to procure the transfer of assets by a company simply as a result of their status as such. This makes sense. Companies require decisions to be made and acts to be carried out by their directors if they are to function, and that alone cannot be a sufficient basis for ascribing the actions of the company to its directors or shareholders. On a similar basis, the upper tribunal rejected the idea that all of the Fishers together could be considered multiple transferors of the assets of the business. It held that it is not possible to consider their actions collectively in order to answer the question whether they procured the transfer, and then treat them as if they had individually brought about the transfer of the assets for the purpose of charging them to tax. I think it's fair to say that the upper tribunal was quite dismissive of the concept of multiple transferors in general, and not just as it applied to this case. That disposed of the appeal on the TAR provisions. However, the upper tribunal again went on to consider what income of Stan James Gibraltar might derive from the transfer and whether the Fishers will be able to take advantage of the motive defence. So I'll touch on those two things very briefly. As to the income which arose from the transfer, the upper tribunal stated as a general principle that this is a matter of fact and degree. They were unable to depart from the first-tier tribunal's decision that income arising from the new businesses that had been developed by Stan James Gibraltar after the transfer had occurred would be chargeable as those were associated operations. The FTT had found that those new businesses only got off the ground because income generated from the transferred telebetting business was used to finance them. So whilst that seems quite a loose factual link, it was a matter of fact for the FTT to determine and not for the upper tribunal to interfere with. As for the motive defence, the upper tribunal found that although avoidance of tax was one of the motives for the transfer, the subjective purpose of the transaction was to save the business, and they noted that the business was clearly doomed unless it followed its competitors overseas. It therefore found that to the extent betting duty avoidance was involved in the transactions, simply the means of achieving the main purpose of saving the business, for which main purpose the transactions were designed. The motive defence was therefore available because the transactions were not designed for the purpose of avoiding liability to taxation. And as a final comment on that part of the decision, although the upper tribunal were careful to state that they considered this conclusion was based on the extreme facts of that case, it's easy to see how similar situations might arise in other cases where a reduction in tax liabilities is a necessary part of future planning to keep a business viable. So that concludes my brief summary of the cases, and I'm now going to pass back to Rebecca to see if there are any questions that we can answer briefly in whatever